Okay, contract law, page 952, chapter 10, third parties' rights and responsibilities, section 3, assignments of rights. We just read the case Chemical Bank versus Rendon Professional Association, and the notes for these, there are 3. Starting with unconscionability, Rendon argued that the waiver of defense clause it had assented to was unenforceable because it was unconscionable. The court rejected the argument in a part of the opinion omitted here. What were the weaknesses in the argument? 2. Alternate rationale. The facts of Chemical Bank might have supported a finding that Rendon made a promise directly to the bank that the bank would be paid notwithstanding any defense that Rendon might have against Intertel. If that promise was made, would it have served as a basis for the decision without reference to Article 9 of the Code? There might be a question of consideration for the promise. What was given in exchange for Rendon's undertaking? The question would be especially acute if the supposed promise was made after the bank had invested in the contract. Rendon could, of course, bargain with the bank for it to make an advance or payment to Intertel if the bank had not already acted. Possibly a promise by Rendon to the bank, if one was made, could be enforced on the basis of promissory estoppel. A showing of something in the way of reliance by the bank would be required. What kind of reliance might be shown? And the third note, titled Variant State Rules. The stance of Article 9 toward waivers by consumers of their defenses was sharply debated in the councils of the Code sponsors as to the Code's neutrality on consumer credit issues. See Robert Skilton and Orrin Helsted, Protection of the Installment Buyer of Goods under the UCC. The decision was, of course, not to strive for uniformity on the issue of consumer protection. Does that fact suggest any attitude that should be taken toward the business buyer? The issue of consumer protection has also been hard fought in the legislators and the courts. A number of states virtually deprive waiver of defense clauses and holder in due course status the respect to notes of their FSC in ordinary consumer transactions. See Uniform Consumer Credit Code, Section 3.307, and other sections cited in the comment. Other statutes provide the consumer with a limited period for raising objections against paying an assignee. In states of this persuasion, the inception of the duration of this period are variables. A description and compilation of retail installment sales statutes as they affect assignment law appear in the introductory note to Chapter 15 of the restatement. Next section, now not talking about Chemical Bank and Rendon, is assignees' liabilities. Efforts now to be described have been made to impose no-fault liabilities on assignees, sometimes by consumers, sometimes by others. The end point of these efforts, which is not even in sight, might be put this way. When a dispenser of goods or services has obtained financing by assigning a customer's account and the dispenser is found to have imposed on the customer may require the assignee to account for its gain or may charge the assignee with the customer's loss. The statutory and regulatory texts have given some impetus to claims against assignees, but also have put them in check. An example is the FTC holder rule, which requires that consumer credit contracts contain this notice: holder of this ... contract is subject to all claims which the debtor could assert against the seller of goods or services obtained pursuant hereto. Restitution claims. Long before that rule was thought of, restitution was thought of as a basis for a claim against an assignee. In Merchants Insurance Company versus Abbott, the facts were such that if the company had paid anything to Abbott, it could have recovered back as money paid under the influence of a mistake. The mistake was that the company was indebted to Abbott under a policy of insurance on a mill which had been destroyed by fire. In fact, the company owed him nothing because he had instigated the fire, and it had paid him nothing. Instead, the company had paid the amount of the loss to the firm Denny, Rice and Company, to which Abbott had assigned his claim on the policy. On learning of the arson, the company sought to recover from Denny Rice the payment it had made. Denny Rice was exonerated. Abbott had made the assignment to satisfy a debt that he owed to Denny Rice. Hence, it took the assignment for value. Denny Rice was not unjustly enriched by having received money that Abbott owed to it. Merchants Insurance Company versus Abbott is the name of that case. That's an interesting case. A comparable claim was made in Michelin Tires Canada Ltd. Versus First National Bank of Boston. This one had some support in UCC Article 9. The rights of an assignee are subject to all the terms of the contract between the account debtor and the assigner and any claim arising therefrom. Emphasis supplied. Nevertheless, the assignee was exonerated. The section quoted was the predecessor of what is now subsection A of UCC 9-404. The current provision contains language disfavoring the claim. For one thing, the former reference to any claim has been changed to any claim in recruitment. Also, the revision inserted section B of the rule of which applicable to the facts of Michelin Tire is the claim of an account debtor against an assigner may be asserted against an assignee under subsection A only to reduce the amount the account debtor owes. So there's now some notes on the, within the assignee's liabilities section. Monitoring costs, and we return to the Michelin Tires case. The court made a policy argument against affirmative actions based on transaction costs. Michelin explained of its contractor, One Corrigan, in an action against his assignee, the bank. The court compared the Corrigan-Michelin connection with the Corrigan Bank connection. To charge financiers of liability would compel them, the court thought, to supervise performance by their customers of the job being financed. A party in Michelin's position would not, however, relax its supervision. The party most interested in adequate performance would be the other contracting party. Given this natural interest, it seems likely to us that while on charging them with affirmative actions, the banks will be given additional burdens of supervision. There would be no corresponding reduction in vigilance by the contracting parties, thus creating two inspections where there was a former one. Costs for everyone thus increase without any discernible benefit. Also, we simply do not believe that the banks are best suited to monitor contract compliance. Does this reasoning cut too deep? That is, does it tend to show that Corrigan's default should be no defense for Michelin when the bank is the claimant? Now we're looking at holder rules part within the assignee's liability section. By an act of the Michigan legislature concerning the financing of motor vehicle sales, an installment sale contract governed by the act is to contain this notice. Any holder of this consumer contract is subject to all claims and defenses which the debtor should assert against the seller of goods or services obtained pursuant hereto. This is installment sale contracts hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. So Michigan COMP laws section 1114 A in parentheses C before the second sentence was added, this provision was held, as that sentence intimates to impose vicarious liability on a holder. It may be noticed that the first sentence parallels the language required by the Federal Trade Commission in its holder rule. One might suppose then that federal law also opens financiers to vicarious liability, but the Congress has acted to limit that liability. It added the following provision to Truth in Lending, which governs applications of the FTC holder rule. Yeah, among like 500 other things. Subject to a qualification, any civil action for a violation of this subchapter ... which may be brought against a creditor may be maintained against any assignee of such creditor only if the violation for which such action or proceeding is brought is apparent on the face of the disclosure statement, except where the assignment was involuntary. The statement goes on to restrict the kinds of apparent violation. Among the debtors who have been balked by this provision was Suzanne Ramadan when she made a claim against the Hyundai Motor Finance Corp. In 2000. Chase Manhattan was another of her targets. That case is of special interest in part because it evoked an interesting response from Judge Pollack, formerly eminent as a law school dean. Dissenting, he wrote, "It seems that a finance company, feeling that the holder notice is in place for via force majeure and intending to defend against its applicability in any litigation that may arise." Should, before accepting assignment of a finance agreement, insist that the holder notice be garlanded with caveat emptors that warn the purchaser-borrower of the finance company's view that the 1980 TILA purchaser-borrower of the finance company's view of the 1980 TILA amendment robs the holder notice of substantive effect. A finance company has no ground for opposing that more than one of tens of thousands of purchase borrowers, the Ramadans of the world, will be conversant with the interplay between the FTC regulation and TILA. Given the disparity in the possession of crucial information, I would conclude that an assignee finance company that failed to insist on inclusion of an appropriate warning adjacent to the holder notice should be stopped from evoking the holder notice in litigation.